Hey guys, it's Kathy. I hope you're doing well. We got a few videos today. Animals. Just some animals. We do have an update on Rolo, the dog I'll play at the end from Colorado. We go to Indiana for a bit. We go to Michigan for a bit. Um, and we get a harsh court. Harsh court that we're not used to. Let's start with though. This video isn't like crazy or anything. It's just funny. It's just the whole content is funny.
Have a seat. People versus Eric Harden. Good morning.
Good morning, Your Honor. For the record, Stephen Barker, still doing this after 41 years on behalf of my client.
How long has it been since I've seen you? It's been forever.
Well, just by luck of the draw, about 2 years, Your Honor.
Yeah. How have you been?
I'm doing well. You look good.
Good. Yeah, everybody's healthy.
I'm aging faster than you are, but then I had a head start.
Because you're getting the stress. I don't get the stress. Yeah.
No, that's right. You get to give it now.
I give it now. Right. Tell me about this plea.
We've had a chance to pre-try this, and we've reached an agreement under which my client will plead no contest for civil liability purposes. The matter will be taken under advisement for 6 months with the condition that the pig not be allowed out, and that if there's to be restitution, that we're requesting a restitution hearing, and brother counsel has promised to provide us with all the discovery that is necessary in order to have the restitution hearing to determine what damage the pig actually did.
All right, so I've got 2 counts of animal at large. Am I taking a plea of no contest on both files?
We are, Your Honor.
Okay, all right, and both files will then be held under a 6-month delayed sentence?
Correct.
Okay, all right. So I'm assuming if the complainant contacts you, then you're going to contact Mr. Barker and we'll get something scheduled if we need
You
to.
can schedule it right now. I understand the 29th is the next time I'm before the court. If that,
I can't do the 29th.
all right, I will have to then, if it's all right, I'll get with Mr. Barker and get Heather and we'll schedule it.
Does that work for you?
Yes, Your Honor.
Okay, all right. Mr. Harden, you've gone over your rights with Mr. Barker. You understand your rights and the options those rights give you.
Yes, sir.
All right. And you understand the possible penalty for these charges.
Yes, sir.
All right. And do you understand, sir, that when you say no contest to me, in essence, what you're saying is, Judge, I'm not fighting these charges. You understand that?
Yes, sir.
All right. So I'm assuming one of you attorneys can give me the factual basis I need.
We'll stipulate to the police report. Your Honor.
All right. Well, I probably don't have a police report.
Okay.
I've got an appearance ticket.
The defense will stipulate that the pig got out on 2 occasions and went across the street to the complainant's property.
Okay. Quiet.
And there's allegations that the pig did some damage.
And that's what the restitution hearing is going to be about.
That's what it would be about, yes.
Okay. All right. I'm satisfied with those facts. If you are, Mr. Barker.
I am, Your Honor.
Okay. What should I know before I set the terms of sentence?
Well, my client has had the pig for 7 years.
No, 8 going on 9.
Excuse me, 8 going on 9.
Is this like a farm pig or one of those
He's a
pot
mini pig.
bellies?
He's a mini pig. Mini
Okay.
Giuliani.
Go ahead.
And these are the only 2 times that he has gotten out that we were aware of. There've been no complaints by any other neighbors. There's been no issues with him getting out since then. The one occurred in the spring when the ground around to the bottom of his pen was soft and he was able to push the bottom of the pen out. The second time is my client's mother accidentally let the pig out when she was going to clean something or whatever. And that's been it. Other than that, there's been no problem since then. As to the restitution hearing, Your Honor, this is involving alleged damage to a in-ground pond, the rubber liner, and probably won't be able to assess that until the weather clears up. And it can be
Well, at least get rid of the snow, right?
looked at. Yes, Your Honor.
It's coming.
Yeah. It's supposed to be 40 this week. Your victim's got her hand in the air.
That's all right. The other thing is that there are some unpaid medical expenses as a result of this particular incident also. So we will put all of that together and present it to the court. But I also give Mr. Barker the information that I have.
Okay. All right. Anything else as to sentencing? The restitution claim, I understand, we're going to deal with that later.
Yeah, yes, sure. Obviously, in terms of medical, we would need documentation of
Sure.
the cause of the medical issues.
Okay. All right. Anything else?
Thank you, Your Honor.
Thank you. I'm assuming you have other animals too.
Was it?
I'm assuming you have other animals as
Yeah,
well?
yeah, we have 3 dogs.
Okay. This is the first animal issue at the location?
Yeah, I've never had a
Well,
large
the first
ticket.
2 animal issues.
Yeah, I've never had
No.
tickets for it.
All right. All right, I'll delay sentence on these 2 files, 6 months on each file. Stay out of trouble, no new violations. On each file, fines will cost $150. That money's due within 5 days. So we need to have it in 5 days, or we need to have a plan in place to get it. So go downstairs, either pay it or make arrangements to pay it. Anything else?
No, Your Honor.
All right, and I'll leave it to you 2 gentlemen to contact Heather to schedule restitution.
We're using the term gentleman very loosely.
Just have it. Just have it. Have a good day.
You do.
Yep. His pigs got out. You know, the poor judge didn't have a police report on the pigs at large. I hate when my pigs get out and they rustle around the neighbor's house. And who knows what these medical expenses are. I was dying to know what the medical expenses were, and I never found out. And we never will, because they're not going to say anything else about the pig going out. All right. Now we're going to go on to a guy who tries to negotiate costs with the judge. It's great.
Good afternoon, sir.
Mr. Chowdhury, you were supposed to pay 175 back in May, and then we never heard from you, and so the balance got up to 314, and now you're asking the court for a reduction in cost. Why didn't you stay in touch with us? Sir,
Sir?
can you hear me?
Yes, sir. Yes.
Can you hear me now, sir?
Yes, sir.
Okay, you were supposed to pay $175 back in May of last year. Why didn't you pay it?
Sir, I don't know, sir. I don't know payment.
Mr. Chowdhury, you came to court and talked to the magistrate in May of last year. You pled responsible. You had to pay $175. You didn't pay, and so it went up to $314. My staff is saying that you would like to have a waiver of late fees. I just need to know why you didn't pay back last year.
Sir, I swear on my mother, sir. Sir, I suffer depression. I don't remember nothing. I live here through 2 days. I live there 5 days. No money. I leave the house. I find something. Sometimes I stay in the car, sir. 1 year, no job. I don't remember. Somehow I find out that I have something going on. So I come today, sir, and I find out this, sir. Please, please, sir, I come to beg. Please help me, sir. Please.
Well, sir,
Give me chance, sir, please.
what are you doing to try to find a job?
Sir, I try, sir. I try. I find some job fact. I can job. I do job like working job. I can do, sir, because my back pain, sir. I can. So I finding jobs, sir. So please.
So what are you asking of the court? Do you need more time?
I ask favor, sir. Please forgive me. Give me chance, sir. Please. I grow
Okay.
up. I understand rules, American rules. I understand. I did not know nothing. I came from poor town. My father, nobody teach me nothing. I don't know rules. I break it because I don't know it, sir. But I know. I learned from my mistakes, sir. Now I know, and I don't break any rules. I follow everything. I just want to beg for favorness, sir. Please forgive me, sir.
Well, sir, you owe the court $314. Originally, it was 175, and it became $314 because you didn't make any payments. So now you're asking for what? Do you need more time to pay the 314? Are you looking for a reduction from the 314? What are you looking for?
Sir, I looking for, sir, forgiveness. Please forgive the amount. Give me chance, sir. I'm not making no mistakes, sir. I'm no depression anymore, sir. Sir, I know rules. I respect American rules, everything, sir. I follow everything. I don't even smoke, sir. Not drink, no smoke. I just want forgive me, please.
Well, I'm not going to erase all the money that you owe at the court. You owe the money, but it sounds like you have some financial issues. So, okay, so I have written to my staff, if you pay $175, then I will close out the file. I'll adjourn the show cause 150 days. So basically, sir, I'm giving you 5 months. And if you pay 175, then I'll waive the rest of the late fees that you owe. If you can't pay it, then you need to show up in 5 months and explain to me your current situation and see if I can give you more time.
Okay, sir. At least thank you, sir. You helped me a lot. I don't know how. Oh, sir, okay. Sir, $100, sir. $100. Can you do $100, sir?
What?
I pay $100 if okay, sir. $100. Only $100, sir.
Well, if you could pay $100, then that'll leave you 5 months to take care of $75.
No, I say he said, sir, $175, 5 months. Okay, I will do it, sir. I find somehow I give you. How
So Mr. Chowdhury, let me walk through this. You have 5 months. If you can pay the 175 in 5 months, then I'll waive the rest of it. If you can't pay it, or you can only pay part of it, come back and see me and we'll talk like we're talking right now, and I'll probably give you some more time to get it done, okay?
Okay, sir, okay.
So if you pay 175 in 5 months, we're done. If you don't pay the 175, then just come back and talk to me and we'll figure something out.
Okay, sir. Sir, what is say? Officer, work tax officer, I don't know. They say my license suspended, sir. Please release it, sir. If it's suspended, sir, please.
Well, let me look at his driving record. I don't know the copy. Let me take a look at your driving record, sir. Just hold tight, Mr. Chowdhury. I've got a couple other cases, so just wait. Chowdhury. Mr. Chowdhury, are you still there?
Yes, I'm here.
Okay. All right. So to collections, he wanted to know what he needed to do to lift his suspension. So I've given him 5 months to pay the original 175, and that will close out the file, and I will waive the balance, which was, I think he had a total of 314. But in order to get the suspension lifted, he at least has to pay $50, and then we'll lift the suspension. All right, does that make sense, sir?
Sir, $50 I pay today, sir, today.
So if you pay, now listen, you pay $50, then we'll lift the suspension. You still have to finish the 125 in 5 months, but I'll at least lift the suspension, okay?
Okay, sir.
All right, now in order to pay, you need to call collections, write down this phone number, ready?
1 second.
Two,
Sir,
four-
1 second. Please, 1 second, sir. Yes, ready.
248,
48
248, 246, 3675.
collection. Okay.
All right, good luck,
I
sir.
I can pay on
Just-
the phone, right?
Just give them a call and they can help you, sir. Unfortunately, I've got other cases I gotta try to manage today, sir, so call them and they can help you.
Okay, sir. So $50 today suspension release, right? In 5 months, 125. Okay.
You got it, exactly, that's perfectly said. Good luck.
Okay. I can go?
You can go. Mr. Cassidy is asking.
Okay, first, Derek is so cute that the slightest case that he has that I like to show. Me and Derek are on first names terms because he's so cute. He's normally not that short with people. He's normally he takes a long time with people. He talks to them, but when he gets mad, he hits the hammer goes down. But it's rare. It's a rare thing that he gets mad. He was annoyed with this guy, and then he was annoyed because the guy was like, "No, I only pay 100. 100 I pay." That's not how it works. You can't just pick how much you're gonna pay. And then he was like, $50. Okay, I'll pay that today. No problem. Well, if you could pay $50, I bet you could pay the whole thing. I bet he could. So this guy went months without making a payment. I don't remember when he first made his payment. Now we're going to go to Indiana, and we're going to check in with a guy who's on probation and see how he's doing.
1905 F322. This is State of Indiana versus Shannon A. Troyer. Mr. Troyer, please raise your right hand. Do you swear solemnly affirm to tell the truth, the whole truth, and nothing but the truth in the cause before the court? If so, please say I do.
I do.
Thank you. Please have a seat. Please state your full legal name for the record.
Shannon Anthony Troyer,
And sir, what was your address prior to being incarcerated, if you recall?
18127 Hedgewood Drive, Goshen, Indiana.
Zip code there?
46526.
Date of birth?
82874.
Last four digits of your social security number.
6746.
All right, looks like we're here for a hearing on a violation. Is there going to be an admission, denial, or something else?
We're going to be admitting the violation and we're ready to proceed with sanctions, Your Honor.
Okay. Mr. Troyer, it looks like we're here today because on December 12th, 2023, Elkhart County Community Corrections filed a notice of violation alleging that you violated the terms of your placement. Have you received a copy of that petition?
I think so, yes.
And have you had an opportunity to review that petition?
Yes.
Do you understand what's alleged that you have done in order to violate the terms of your placement?
Yes, ma'am.
It is my understanding you wish to admit that you violated the terms of your placement, but before I can accept such an admission, I must satisfy myself that you're aware of the legal effect of that admission and that you're aware of the fact that by making such an admission, you're waiving certain constitutional and statutory rights. I will do so by asking you a series of questions. Please answer my questions orally. Do you understand that you were under no compulsion to admit that you violated the terms of your placement, that you can require the state of Indiana to prove that you've done so by preponderance of the evidence?
Yes.
In the event that you deny that you violated the terms of your placement, a hearing will be held to determine if you've done so. The state of Indiana will present evidence at that hearing. This is typically done through the testimony of witnesses. You have the right to confront and cross-examine the witnesses called by the state of Indiana at that hearing to prove that you violated the terms of your placement. Do you understand that?
Yeah.
You also have the right to the assistance of this court and compelling persons to appear at your hearing in order that they testify as witnesses on your behalf, and the exercise of that right costs you nothing. Do you understand that? You also have the right to be represented by a lawyer at all stages of these proceedings. And if you cannot afford the services of an attorney, I'm obligated to appoint counsel to represent you at no cost to you. Do you understand that?
Yes.
You also have the right to remain silent regarding any allegations referring to new criminal charges. However, in regards to any other allegations, you do not have the right to remain silent, and you must answer questions when asked. Do you understand that?
Yes.
Do you understand that if I find that you violated, do you understand that if I find that you violated the terms of your placement, I can revoke your alternative placement and place you at the Indiana Department of Corrections or the Elkhart County Jail, whatever the case may be, for the remainder of your sentence. I could also continue you on community corrections. Do you understand everything that I've explained to you?
Yes, ma'am.
Do you still wish to admit the violation?
Yes, ma'am.
Factual basis, please, Mr. Bannock.
Thank you. Shannon, were you validly placed on a term of community corrections through this court under this cause number?
Yes.
And had you moved from home detention to daily reporting at ECCC?
Yes.
And one of the terms of daily reporting was that you're supposed to check in every day. I mean, hence daily reporting. And on December 10 of 2023, did you fail to report in?
Yes.
As far as factual basis goes, Your Honor, I think that's sufficient.
All right, anything further on a factual from the state?
Yeah, Your Honor.
Court finds a knowing involuntary admission. The court finds a basis in fact that the defendant violated the terms of his community corrections placement by not reporting as directed by Elkhart County Community Corrections. Mr. Troyer, is there anything you'd like to say on your own behalf in regards to sentencing? You don't have to say anything.
I'd like to apologize to the court that we're all here. I was under a lot of stress and I don't know, I forgot. I don't know how I did it. I'm sorry.
Thank you.
Thank you, Your Honor.
Mr. Paddock?
Your Honor, Mr. Troyer, as you may have gleaned, is not a man of a lot of words and is very, very nervous being before you today because he understands that you could send him to the Department of Corrections. We're hoping not. As you realize, or as you read in the violation, he had been doing very well with ECCC, moved from home detention to daily reporting. He was clean on all of his drug tests. He missed December 10th, but went in on December 11th to report to his caseworker. She did a drug test on him that day, and it was a clean drug test. So what he didn't do was he didn't check in like he knew he was supposed to. Mr. Troyer indicates to me that he has recently become more involved with his son, his 8-year-old son, who had been living with him for about 3 months at that point in time. At the Hedgewood Drive, Mr. Troyer, his mother, and his son were living there when all this occurred. He had a job with Lippert that he'd worked at for 2 years, and his hours were typically 3 p.m. until 2 a.m. So he worked 11 hours a day, 5 days a week. And between picking up his son, getting him to school, et cetera, Mr. Troyer advises me that basically he wasn't sleeping because of the hours when he needed to be there for his son and the hours that he needed to be at work. He does have a valid driver's license. He's got a vehicle. He's got a good place to live with his mother on Hedgewood Drive. He's not sure if his job is still available to him or not. I told him that he would hold it for a period of time. That period of time has lapsed. He voluntarily, once he met with his caseworker the next day and she told him she was violating him, he voluntarily showed up at the jail on December 12th and has been in continuous custody from January 12th and December 12th until today. Mr. Troyer is, again, he's very apologetic. He has no excuse as to why he didn't do that other than when he was going to check in, he was running late for work, and there would have been problems with regard to work consequences. Obviously, there's been far more serious consequences at work and in his life because of the warrant and because of his behavior. We're not denying that. What he is hoping, and if you review the report from ECCC, They indicate that they would absolutely take him back, and that's what they're recommending, is he be placed back on ECCC. We're hoping that you will accept that this is a sufficient sanction from December 12th until today for him missing the check-in, which again was very out of character for his time at ECCC, where he's done excellent as far as no issues on drug tests. When you told him to do 90 meetings in 90 days, he did all that. He did all the classes. He's done everything except on December 10th, he didn't check in, which was a problem, and he has no excuse for not checking in other than stress and lack of sleep. Thank you, Your Honor.
Thank you. Ms. Stewart?
Thank you. The court, or the state will leave this to the court's discretion. Thank you.
Mr. Troyer, I was reviewing your case, and it looks like I modified you out on April 7th of 2022. At least that's when the order was tendered. And I have a very specific kind of script that I go through in regards to when I modify somebody out and what I expect of them. And I'm pretty sure I did that with you. You indicated that you were living with your mother, that you indicated to me that you had done what the court asked you to do, that you were doing well. And now I hear that you weren't checking in with community corrections. Mr. Troyer, being an adult, there are certain things that you have to do, and one of those is follow the rules. It sounds like if you're not getting sleep and you're stressed out, that something has to give. So the fact that you missed one appointment and you were on zero tolerance, and that's what I'm teetering between. Because Mr. Troyer, if you go back to the same thing you were doing and you're stressed out with a lack of sleep, you know what comes along with that? A breakdown in your judgment, and you're returning to drugs. So am I just prolonging the inevitable? What plan do you have if you're working nights, but yet you're taking care of your son during the day and you live with your mother? Why is it that you have your son? Like, why do you have him 24 hours a day and you're picking him up from school?
His mom isn't able to do it.
Isn't able to do what? Pick him up from school?
Be a parent.
Okay.
I'm just my first time trying to be a parent.
And
the guardian, his guardian died.
Okay.
Like 3 months, and then I stepped up and took him. It's
All right.
a big responsibility.
It's a big responsibility.
You taught me a lot of responsibility, man.
It's an even bigger responsibility to take care of somebody else.
My mom's trying to help me.
But she raised you. She did her job. So.
I was going to change shifts to try to go to first shift. I had a lot of things in the process of changing shifts at work to just trying to, so while he's at school, I'm at work. So everything worked better. My work, I was trying to do a lot, man.
I know, and that's why I warn people about.
I really do appreciate everything you've done for me with all this time.
Because, zero tolerance is generally zero tolerance. The only thing that you have going for you, Mr. Troyer, is that you did not turn back to drugs. So that's why I'm considering putting you back on community corrections. But if I do that, am I just prolonging the inevitable? Are you going to get your act together?
It's almost there, man.
Horseshoes and hand grenades. You're close.
I will not be back in this courtroom. If I do come back in this courtroom, I know where I'm going.
Well, that's where I told you I was going to send you last time. So that's why I'm saying, are you still going to AA and NA classes?
I go on Saturdays.
Okay. Do you have a sponsor?
Yeah, Gary Stopper.
Okay. So you're still talking to your sponsor?
I've been real busy the last 3 months and I haven't talked to him.
All right. You know what happens when you get complacent. So I'm going to order that you contact your sponsor at least one time per month. Actually, let's make that 2 times per month. That you go to AA and NA meetings, continue those at least 1 time per week. More if necessary.
Like my sponsor likes to go to breakfast on Saturday morning.
There you go. Go to breakfast every Saturday morning with your sponsor. That way you guys can touch base, have grandma watch your 8-year-old. Well, I don't know if there's still Saturday morning cartoons, because I used to like those. Oh, that's too bad. Although there's now the Cartoon Network. There's cartoons 24 hours a day. All right. Oh, my original was to go to NA and NA meetings 2 to 3 times per week or more. So,
I did that for a long time.
well, that's for the remainder of your sentence. So I'm going to move that to NA, AA and NA meetings 2 times per week. Back to my original sentence there. I was just looking over what I was having you do. And you might have to go through some additional counseling to make sure that you're handling your new role as a parent proficiently. Now, if you feel that you're getting overwhelmed, then that's when I want you to seek out a counselor. Because, Mr. Troyer, if I see you again for any reason whatsoever, even if you missed an appointment with day reporting, I will send you back to the Indiana Department of Corrections for the remainder of your sentence. You understand this?
I understand.
I don't do this very often. You can ask your attorney. You're one of the rare cases, and the people that I have gone out on the limb in are usually back. So it's almost like the kiss of death. So, like I said, I don't want to just prolong the inevitable, Mr. Troyer, but I will release you back to Elkhart County Community Corrections. They will hook you up here, and then you will continue your sentence. So you're gonna have contact with your sponsor at least 2 times per week, and you're gonna go to ANA and AA meetings at least 2 times per week. So I want to keep you on track because you have an 8-year-old child. 8-year-olds take in everything. If you are not doing what you're supposed to, they're going to see it, and they're going to think that that's what you need to do. You understand that?
Yeah.
The worst thing you can do is turn back to drugs, because what's that's telling me is you love yourself more than you love your 8-year-old. You understand that? And I will send you back to the Indiana Department of Corrections in a heartbeat. Understand that?
I believe you.
Okay. Anything else?
Judge, so he's not just he was on daily reporting, so there was no.
He's being released back to community corrections at a level that they deem appropriate. And maybe day reporting is not the thing for you if you have to go every day. So I'm gonna leave that to community corrections. If they want to,
They'll meet him here.
they'll meet him here and decide where he goes.
Okay. All right. Yeah. All right. Thank you, Judge.
Thank you.
This man reports every day. Every day. No, he gets tested all the time. No missed tests. His tests are all clean. He's paying his court fines like he's supposed to. He's doing every single thing he's supposed to. And he missed one check-in. One check-in in December. And she was going to throw him back in jail. And she usually does. I mean, she doesn't play around. 0 tolerance. She means it. She definitely means it. I don't know why she let him back. I don't know what was going through her head. I'm glad she did. But that's crazy because everywhere else, you see these people who are on probation and they drug charges and assault charges and domestic violence charges and 3 months of non-reporting and all this stuff, and they go right back on probation. We're going to add another 3 months to your probation because you did this, but they're still right back on probation. This guy missed 1 appointment. 1. That's Indiana. I have another case with her that's a little suspicious. I don't know who to believe, but first we're gonna stop in on Rolo. Rolo the dog. If you remember, so this is in Boulder, Colorado. It's in Colorado. I think it's in Boulder, but I'm not 100% right now. So this son had a dog. He's an adult, so he's not a little kid. He had a dog, and the dog bit two different people on two different occasions. So they placed, restrictions on this dog, Rolo. He always had to be muzzled. He always had to be on a leash. Well, Miss Lightfoot is her name. She was driving through Boulder to go somewhere else, and she had a warrant out for her arrest. So she got pulled over. So when the police pulled her over, Rolo was in the car. And she said, I gotta leash him. I gotta leash him. You gotta let me leash this dog. The police wouldn't let her put Rolo on this little leash that was attached to the car. And Rolo got away. She was she was arrested. So there was nothing she could do about it. The police let the dog get away. The dog did not bite anyone in this time. The dog ran to her job or somewhere she used to work or something like that. And the employees there reported the dog there. So because the dog got away, she got in trouble for that because the dog's not allowed to be at large. Not this dog. He's aggressive and he hurts people. So it's the police's fault that the dog got escaped, not hers, but she got in trouble for it. So they wanted to euthanize the dog. So they had a case 2 weeks ago, I think, 1 week ago. I don't remember. It's in the link. The link is in the description to the first part. So the judge has given her a chance to get a lawyer to fight this, and now they had the decision. They had a decision a couple days ago. It was a 3-hour decision. It was a 3-hour hearing. So no, I'm not. We're not going to go through the 3-hour hearing here. I'm just not. I don't have time. But I did post the whole 3-hour hearing in the members only area. I just uploaded the video. I didn't talk or anything, and it's there if any of the members want to see it. But here is just the decision.
Okay, we're back on the record in the Sarah Moonshadow case involving the city's motion for forfeiture of Rolo. I took a brief recess so that I could gather my thoughts and do my order here, or an oral order, which I will follow up with a written order, which may take me a day or two to get out. But the oral order will be effective as of this afternoon. The city's motion for forfeiture comes under section 6127 and 6128 of the Boulder Revised Code, and pursuant to those two sections, if the city proves that a dog is aggressive, and in this circumstance under a preponderance of the evidence standard, if it proves that initial fact, then the court is to turn to section 6126 of the Boulder Revised Code and determine whether forfeiture of the animal is in the best interests of the health and safety of the community when weighing that against the interests of the animal or the dog. And so I'm going to start with the first prong of this evidentiary standard, which is whether or not there is evidence to prove that Rolo is an aggressive animal. And under section 6120 of the Boulder Revised Code, that defines an aggressive animal. And in this particular case, there is evidence that's been presented in two separate cases that resulted in guilty pleas by the two defendants who were responsible for the dog at the time. CR 21-1889. And CR 23-4113. Both of those cases involved circumstances where two separate incidents, the dog known as Rolo was aggressive and actually bit individuals. On March 26th of 2021, in case number 21-1889, a person by the name of William was bitten. He was a passerby who was bitten by Rolo when the defendant, Miss Moonshadow's juvenile daughter, was walking her dog. That bite was not as severe as the second bite that occurred on September 23rd of 2023 when Rolo bit defendant's neighbor, Daniela Montez. Officer Whittle testified about her review of the reports in the March 26, 2021 incident, and also testified about her involvement in the incident on September 23rd of 2023. In both of those incidents, I'll just point out the defendants pled guilty to the charge of aggressive animals, so there's no question in the court's mind that the city has met its burden to prove that Rolo was aggressive. But some of the details pertaining to the incident, I think, is worthwhile. On both of these incidents, there was nothing to suggest that Rolo was provoked in any way. The March 26, 2021 incident, there wasn't any evidence to show that the other individual, the victim in this case, provoked Rolo to bite him. And in the September 23 of 2023 incident, there's actually a video that Officer Whittle has observed and watched, which she described as showing that Rolo literally slipped past Nicholas Edwards, who was the defendant's son, got out of the vehicle and got past the defendant to Mr. Edwards and went and bit Daniela Montez. There was no provocation, and according to Officer Whittle from the video, there wasn't any indication that Ms. Montez or her daughter, who was with her at the time, even knew that Rolo was going to be aggressive or had any interaction with Rolo prior to that incident. So again, a very clear and unprovoked biting incident. And on this particular incident, an increase in the severity of the injuries. Pretty severe bite to Ms. Montez's arm, which was swelling up at the time that that Officer Whittle saw Ms. Montez, which was that same day. And as she was interacting with the medic who was going to transport the victim to the hospital, the medic clearly told her that she thought that there was a fracture to the arm. And so the swelling combined with the medic's conclusion was then supported by radiographic findings later that there was actually a fracture to Ms. Montez's arm. So no question in the court's mind that in fact Rolo was aggressive on both of those incidents, March 26th of 2021 and September 23rd of 2023. City has proved that by a preponderance of the evidence. The next step for the court is to look at the standards for forfeiture of an animal pursuant to section 6126B of the Boulder Revised Code. And it says in making a forfeiture determination, the court is to consider without limitation the following factors. And we'll start with paragraph A, whether or not the animal attacked a human being. The answer is yes on 2 separate occasions. Paragraph B, whether or not there existed any provocation or other extenuating circumstances relevant to the animal's behavior. No evidence to support any idea that there was provocation. The ideas that were promoted by the defendant here today was this concept that perhaps Rolo was aware of mistreatment of the defendant on prior occasions by perhaps Ms. Montez or people who were involved with the place where Ms. Montez lived and where Ms. Moonshadow lives. But no provocation that day, and that's a big stretch to somehow make that an extenuating circumstance. If anything, it's a circumstance that militates in the opposite way, that the dog might, from a protective response and from responding to the emotions of his guardian, might attack someone else who the guardian might not have a good feeling about. That's very concerning to the court. It's not a mitigating circumstance in any way. Paragraph C, any aggravating factors relating to the violation for which a defendant is being sentenced. This isn't sentenced, but any aggravating factors. The aggravating factors are all kind of part of this whole analysis, which it comes into the probation, which I'll get to in just a few moments. Paragraph D, the number and severity of any prior attacks on human beings committed by the animal. I just described those. There were 2 separate incidents. Any factors relating to probability of future attacks by the animal. With an animal that's been on probation now on 2 separate occasions by this court with very strict provisions and conditions set forward for the defendants in both of those cases to follow, and the fact that they weren't followed, those conditions weren't followed, that increases the likelihood of another attack on a human being being committed by the animal, because if there is a possibility that the animal would commit one, it's more likely when the folks who are responsible for the animal aren't able or perhaps even willing to comply with the very significant and strict conditions that were set forth by an animal evaluation and by the court on a prior occasion. So that militates also in favor of forfeiture. And then you take a look at the other factors, the existence or non-existence of prior animal at large incidents involving the animal. I don't really have that. I think that Mr. Reynolds discussed the at large circumstance on December 25th. That's a fairly difficult one to get your head around because of the fact that the animal was really contained in the vehicle until the officers arrived. And then when the officers opened the door to the vehicle, having required to do so because they had to impound the vehicle after the arrest of the defendant on the outstanding warrant. They didn't have a choice but to try to get the animal outside. But it wasn't a dog at large circumstance that was created by the defendant. And although there may have been, it may be this provision as far as strict liability, this is not something that I'm really putting much weight on one way or the other. And then paragraph H says evidence that other corrective action on the part of the guardian of the animal will lessen the chances of future violations of the law involving the animal. Really nothing for me to feel comfortable about as far as corrective action, because that was where we were when the probation conditions were set on the October 17th of 2023 hearing. Those corrective actions that were expected, which was to basically have Rolo live in a very rural area where Rolo had no contact with other human beings other than Nicholas Edwards, wasn't followed. Everything else beyond that is superfluous. That condition was not followed. That was a significant factor, a significant corrective action that was anticipated being followed that was not followed. And so I will stress that in a few minutes when I read from the evaluation, which is the last condition, which is any expert evaluation of the animal, which is placed before the court for evaluation. There was an expert evaluation that was conducted in this case in the October 17th of 2023 sentencing, incorporated that evaluation from the Humane Society of Boulder Valley. But I want to read from that because I want to make it clear as to why we are here. And it is tragic. It is awful that we are here, but I want to make it clear as to why we are here. And as I don't want to be punitive about that, but I also want to be clear. And I have to be clear on my ruling. So when we talk about case number 2023-4113, that criminal case that was from September, there was an evaluation that was done at that time. And there's a pretty lengthy evaluation that was done at the Humane Society of Boulder Valley. But when it came down to the recommendations from the evaluator, this is Ms. Hartledge, I'm going to just read to it. Nick communicated to me that he lives in a trailer on 69 acres in rural Colorado near the town of Walsenburg. Rolo used to live in Boulder with Ms. Moonshadow, but now permanently lives with Nick. They mentioned, which means it was both Nick and the defendant, Ms. Moonshadow, who she acknowledged that she was present at the sentencing, and there was testimony indicating that she was present during this evaluation. They mentioned that sometimes Rolo goes on car rides with Nick and to tennis courts or to a lake in Walsenburg or La Vida. Nick stated he lives so rurally that he has no trash pickup, no mail delivery, no meter monitoring. This mitigates the occurrence of many of the unfamiliar people that one who lives in a suburban environment might frequently encounter. Currently, Nick allows Rolo to be off-leash on his property. Rolo receives vet care from a mobile veterinarian in Walsenburger while wearing a muzzle. Because of Nick's living situation, it sounds possible for Rolo to live out his life needing only to interact with Nick, Miss Moonshadow, and a veterinarian. For this reason, it may be reasonable to allow the return of Rolo to Nick with some very strict stipulations in place. These stipulations would include the following. And then it goes through a description of the harnesses and the basket muzzle that needs to be worn every single time that Rolo were to leave that property. Rolo wasn't even on that property. It's pretty clear from what Ms. Moonshadow has testified to and what's evident in front of the court that a decision was made to not have Rolo stay at that property. So as soon as maybe within at least a few weeks, perhaps even sooner, of that order being placed and where Rolo was released back to the custody and care of Nick, that Rolo was back in the custody of Ms. Moonshadow and with Nick, but was not in a rural area near Walsenburg, but was actually in Boulder and living in a car or living with Ms. Moonshadow, whatever that might be. That was the main violation of the court's order of October 17th of 2023 and of the very strict condition and expectation from the expert, Ms. Hartledge, of the only way that this dog could be returned to its owner and the community to remain safe. And it simply wasn't followed. On November 21st of 2023, Officer Whittle interacted with Nick and saw Rolo in the vehicle, clearly not in rural Colorado, but in the defendant's vehicle at the time, wasn't wearing a muzzle on November 21st. And then on December 25th, the evidence is clear that, again, Rolo was not in rural Colorado and wasn't wearing a muzzle inside the defendant, Ms. Moonshadow's car when she was transporting Rolo to Weld County, Colorado to spend 3 days with her and a paraplegic that she was caring for. I share the sense of surprise and concern that Mr. Reynolds shared, thinking about the idea of Rolo, this very strong, physically capable dog, a dog that it was able to bite and harm 2 separate people on other instances, was going to be spending 3 days with the paraplegic. Those are big concerns. And I know that Ms. Moonshadow may want to respond to those. Those aren't the bases for my decision. The basis for my decision is what happened following Rolo's release on October 17th of 2023 and the lack of actual follow through with the requirements that were expected following that release. But I nonetheless am very concerned about that, the fact that that occurred. I'm also concerned about the fact that there were 5 additional one-on-one consultations which were to be completed, none of which we have evidence were completed. That there wasn't any follow-up in connection with that training expectation. That in a sense, Mr. Edwards and tacitly Ms. Moonshadow agreed to conditions that they didn't follow through with. And I have no confidence that those conditions, if were reinstated again, would be followed through with again. And although this most recent circumstance of December 25th did not involve an aggressive animal incident, it makes the court aware now, by virtue of the fact that the dog was taken into custody and by the fact that there was a hearing that came before the court, that there wasn't compliance with the court's expectations. And because of all of that, weighing all of those circumstances, I really have no choice. And it pains me. I can't even begin to tell you how hard it is for me to enter an order like this. It's the toughest thing that I have to do as a judge, which is to order the forfeiture of a dog. But this is not a situation that was created by the folks at Animal Control. It was not a situation that was created by Mr. Reynolds or by Officer Whittle. This was a situation that was created by others and by the people who were responsible for Rolo's care. And so, although as painful it is for me, and I have considered Mr. Haas's testimony, I have considered the exhibits and the testimony that was offered by the defendant, the evidence is really overwhelming here that I have to order forfeiture of Rolo. And that means forfeited to the Humane Society, forfeited to the city, but ultimately delegated to the Humane Society of Boulder Valley. And then they have the opportunity to make a determination as to what to do next. I think we all understand that because of what was shared at the last hearing, that the Humane Society is not in a position where they can rehome this animal. So I understand what this means, and it means that it's likely that the Humane Society will humanely euthanize Rolo. And it hurts my heart to have to say that. I wish I didn't.
I couldn't let it get beat up.
I'll finish with this last comment, or one more part of this order, and then a comment. At the last hearing, I advised Ms. Moonshadow that if I did delay the hearing until today's date, that she would be responsible for the expenses associated with Rolo's impoundment and care at the Humane Society. So that will be part of this order, and that is not to add insult to injury.
Yikes.
This is a horrific and tremendous loss for her and for her family. But that is what's required of me, is to require that the person who is responsible for Rolo's impoundment ultimately be accountable for the expenses associated with that. And then my final comment is, when I see a person who has such a deep connection with the dog, I don't take that lightly. I have had dogs my entire life, and I have a dog now. And my wife is as connected to our dog as any person I've ever experienced being connected to a dog. I know those relationships are deeper than some people might think. They provide a great deal of love and care and emotional support to human beings that many people just can't understand. I do understand it, and that's what makes this so much harder, is because it's going to be a huge loss for you, Ms. Moonshadow. I know that. And I'm really, really sorry that I have to do this. But the protection of the community is the most important thing at this point. And there have been 2 prior incidents, and now a lack of compliance with the responsibility to keep Rolo in a place where he wouldn't be in this position. So I'm very sorry for that. I will do a written order following up with that, but the Humane Society does have the authority at this time to humanely euthanize Rolo. Mr. Reynolds, do you have any questions or comments?
I don't, Your Honor. Thank you very much. And I just want to say that I'm very, very sorry for Miss Moonshadow, and my heart goes out to her and her family. And I hope that she can find some semblance of recovery after this.
Thank you for that, Mr. Reynolds. All right, so we can go off the record. Officer, it may take me some time because I want to have a very clear order, so it may not come out this afternoon. I have a police department function that I was supposed to go to, so I'm going to go to that, and then I will get writing when I get back from that, and hopefully have something by the end of tonight, but it may not, and tomorrow's a pretty lengthy day with other things going on, so it may not be until Friday morning. My hope is it's much sooner than that, and if I have the ability tonight, I'll get it done tonight, and then we'll make sure that it gets emailed to you, and then you can follow up with the folks at the Humane Society. You do have the authority, because you were here, to let them know what my oral order is. If they want to wait for a written order, that's fine as well. But I wanted to share that with you, and if we can just allow Ms. Moonshadow some time here in the courtroom on her own, and then she can leave when she's comfortable, and then Nick, you can come back in and lock it up after she's had a little bit of time to absorb all of this. I know it's really painful.
And I'll leave my cell phone number again for Sarah, and I will help out with arrangements at the shelter as far as
He cuts off the video there. I wasn't going to post this because after the last hearing, I won't say the judge offered hope, but it felt like the judge was offering hope that Rolo, you know, so the second bite happened because they put the dog on these anti-anxiety meds to help his aggressiveness, but these meds had a side effect of lowering the dog's inhibitions, and the vet told her that this medicine was going to lower the dog's inhibitions, and the dog was in that state when the dog bit the second woman. And then the police are the ones that lost the dog, not her. And the dog didn't bite anyone or was aggressive to no one at all when the dog was at large. The dog just ran to the job, and they found him. So he gave hope. So I wasn't going to post this because everybody who watched the first one could live out their lives thinking, oh, she probably got. Rolo's probably fine, but you guys did invest in it, so you should find out what happened. So that's what happened. I'm not gonna comment on right, wrong, or indifferent, because it's just sad. It's just sad all over. But now we know the fate of Rolo. Now we know what happened. All right, let's hear Victoria yell at someone. Maybe that'll make us feel a little better. I don't know.
On YouTube. So, okay, this is Universal Collections LLC versus Lenitria Pines. Counsel, can I get your name?
Yes, thank you, Your Honor. My name is Robert Warner, P48843, representing Plaintiff Universal Collections.
All right, and Ms. Pines, can you tell me your name?
My name's Lenitra Pines.
All right, thank you, ma'am.
Morning.
All right, so we were here a week ago on this case, and there were some issues, and Ms. Pines made an argument that she hadn't actually signed onto the lease because she did not initial each of the bottom of the pages, but she did sign the last page as a tenant. I have reviewed the file, Ms. Pines, and you did receive personal service. There's an affidavit in the file that you received personal service of this complaint. And I'm definitely, I'm sympathetic. And I think that, there could be something to your argument, but I'm ultimately limited by Michigan court rules. And I'm limited in that I can set aside the judgment only if it is filed within, the request is filed within 21 days after the judgment is entered. We had a substantial period here between the time the judgment was entered and the time you filed to set aside the default. And I would have given you some credit. I know you did file the objection to garnishments, but even if I use the objection of garnishments date, you were well beyond the entry of the judgment.
Your Honor, may I speak?
You may.
I was never properly served. Even
you were.
Even looking at the example, the exhibit that they provided, the description they give is a Black female, late 20s, dark hair, thin. That could be and have been anyone in my building. I live in a apartment complex with several different people. I was never properly served because I would have never had let it got this far because it's not my debt. I would have showed up for court and I would have explained then and there that it's not my debt. It's a very vague description that they give. That could have been anyone. It's provided in Exhibit 1.
Ms. Pines, I don't doubt that you were out of the apartment, but you signed the agreement is with you, and there's an affidavit from someone indicating that they served you. And I understand that Black female, late 20s, dark hair thing could be a lot of women, but it was served at your residence to somebody who was an adult at the very least. And Ms. Pines, I want to be clear. I'm sympathetic to you, but I cannot. I have to follow the law.
Ma'am, they could have definitely served it to an adult. They
I
could
have to deny your motion to set aside the default judgment because the Michigan court rules do not allow me to do so.
Judge, I live alone. I live in a apartment complex with other families. Like it's a building.
No, Ms.
Building with
Pines,
4
it says it
people.
was served at your residence. And last time we were at court, you told me you lived with other adults at the time.
No, I didn't. No, I live at Aurora with my mother. That's what I was explaining to you, that I live at Aurora, the property that they're trying to sue me for. At that time, I was living with my mother. My property that I just got put out of, I was living by myself. It was just me, but it's a building.
Ms. Pines, the court rules do not allow me to grant you the relief you are seeking.
And can you explain?
So I have to deny your motion.
I'm confused why it's being denied, because I was never, like I just said, I was never.
Because you signed the lease. There is a notice that you were personally served. You did not file your motion to set aside the default judgment within the 21 days mandated by the court rules. There are a litany of reasons that I am bound by Michigan law and cannot set aside this default judgment.
Okay, well, Judge, you do know that the lease expired in 2020 and that the money that they're trying to sue me for is for 2022 through February.
I know, but Ms. Pines, you don't have any proof. Ms. Pines, you don't have any proof that you served the landlord notice that you were vacating the premises. And the individuals that you signed that lease with continued to live there. So I'm trying to explain this.
I guess I'm confused, Judge, because I get what you're saying, that I signed the lease. I hear what you're saying. I get what you're saying. But I guess I'm confused because it expired in 2020 and I moved in 2021.
Clause in it that says if you continue to reside at the premises, there are 2 clauses in there. One is that if you continue to reside there, you would become a month-to-month tenant. And the second, the holdover clause, that's section 28 of the lease. And there's a notice section as well that says if you vacate, you have to give written notice. And you don't have written notice showing me that you vacated that premises. And I know you presented another lease that shows you no longer resided there, but you don't have proof of a written instrument that showed you notified the landlord that you would no longer be residing there. And if I had that piece of paper and you could show that you provided that written notice that you had vacated the premises, we might be in a different spot. But I have to follow the court rules. So that's my ruling. And Ms. Pines, I'm sympathetic, but I'm governed by court rules. So we're all set. I'm following the law. And I cannot grant your motion.
Okay, so I'll just have to search for that letter and then I'll just have to fight this because I can't. Yeah.
Yes, please search for that letter.
Okay, thank you.
All right, thank you.
Yep. Have a great day.
Will she find her imaginary letter? I doubt it. I highly, 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 highly doubt it. Okay. This next one, I'm not exactly sure what I think, so I'm not going to say anything either way. But I don't know who's right. You guys decide.
Solemnly affirm to tell the truth, the whole truth, and nothing but the truth in the cause before the court. If so, please say I do.
I do, Your Honor.
Thank you. Please have a seat.
I'm sorry, I don't know the zip code.
That's fine. Ma'am, please raise your right hand. Do you swear solemnly affirm to tell the truth, the whole truth, and nothing but the truth in the cause before the court? If so, please say I do.
I do, Your Honor.
Please state your full legal name for the record.
Bambi Lynn Beatline,
What is the area code for your cellular telephone number?
574.
Thank you.
Sorry.
What, I have your prior address. What is your date of birth?
247.
Social security number. And you've received a copy of your charging information, is that correct?
Yes.
The purpose of this hearing is to inform you of the allegations against you and what your legal rights are. If you do not understand the charges or your rights, please let me know and I'll explain them to you more fully. You have certain rights that are guaranteed to you based on the Constitution of the State of Indiana, the United States Constitution, and they are as follows. You have a right to have an attorney represent you during each stage of a criminal case. If you cannot afford to and you qualify, the court is obligated to appoint an attorney to represent you. If you're requesting the court appointment of an attorney to represent you, you should do so as soon as possible. You have a right to have a public and speedy trial by jury. You have the right to have the state of Indiana prove each and every element of the charge or charges against you beyond a reasonable doubt. You have the right to see, hear, confront, and cross-examine any witnesses that the state of Indiana may call to prove its case against you. You have the speedy power of the court to compel a witness to testify on your behalf. You also have the right to appeal the decision that is reached in your case to the appellate court or the Supreme Court, as the case may be. However, if you plead guilty, then there may be only a limited right of appeal. You also have the right to remain silent. However, if you give up that right, anything you say can be used against you. Do you understand these rights as I've just explained them to you?
Yes, Your Honor.
You also have the right to know what the charges are that the state of Indiana has brought against you, and they're set forth in a charging information that was filed with the court on October 4th, 2022, and that charging information omitting formal parts reads as follows. The affidavit and the probable cause affidavit filed herewith swears that on or about September 2nd of 2022, the County of Elkhart, State of Indiana, 1 Bambi L. Dightline did knowingly exert unauthorized control over property of the person, to wit, property of Walmart, all of which, with the intent to deprive Walmart of the value or use of any part of said property, all of which is contrary to the form of Indiana Code 354342A, contrary to the form of the statutes, such cases made and provided, and against the peace and dignity of the state of Indiana. There's a page 2, that charging information, which omitting formal parts reads as follows. The affidavit and the probable cause affidavit filed herewith swears that on or about September 2nd of 2022 at the County of Elkhart, State of Indiana, 1 Bambi D. Dayline, heretofore charged on page 1 hereof, had a previous unrelated conviction as defined in Indiana Code 1-1-2 subsequent of retail fraud, second degree, in the 70th District Court under cause number 16-002711-SM, situate in Saginaw County, Michigan, on or about December 6th of 2016, all of which is contrary form of Indiana Code 354342A1C, contrary to the form of statutes in such cases made and provided against the peace and dignity of the state of Indiana. On page 1, you're charged with theft as a Class A misdemeanor, which is elevated by page 2 to a level 6 felony. A Class A misdemeanor is punishable up to 1 year in jail and up to a $5,000 fine. A level 6 felony is punishable up to with an advisory of 1 year, where 1.5 years can be added for aggravating circumstances, and half a year subtracted for mitigating circumstances, leaving the range of incarceration 1.5 year to 2.5 years and up to a $10,000 fine. The statutes pertaining to theft are found in Indiana Code 354342A1C, which the prosecutor will now read to you.
Thank you, Your Honor. A person who knowingly or intentionally exerts unauthorized control of the property of another person with the intent to deprive the other person of any part of receives or value commits theft. The offense is a level 6 felony if the person has a prior unrelated conviction for theft or criminal conversion.
Do you have any questions either regarding your rights, the possible penalties, or the charges against you?
They situated in Saginaw, Michigan. No, I beat that case.
Well, that would be something that either your attorney or you can present to the court, present to the prosecutor's office, because I don't have any information on that case.
Okay.
So I will go ahead and enter a preliminary not guilty plea. It becomes a formal plea of guilty in 20 days. There are certain motions and defenses that must be filed within those 20 days or else they're waived. Do you have another question?
No, you kind of put down 20 days on this that I owe to file.
I don't. What's that?
Sorry.
Do you plan on having an attorney to represent you?
I would like a court-appointed, please.
Are you employed?
No.
Do you have anything worth more than $500 that you can sell to obtain your own attorney?
No, ma'am.
Do you have any family or friends that you could borrow the funds from? Court hereby appoints the public defender's office to represent you. The next thing I'm going to go over is that date sheet. You don't need that first date because that is the attorney appearance. I've already appointed the public defender's office to represent you. Your next date is the omnibus date, which is just a calendar date, which is March 7th, 2024. There'll be no court hearing on that day. Your change of plea, your status conference hearing is set for March 14th, 2024, and that'll be in the morning sometime. The exact time will be assigned closer to your hearing date. Your pretrial conference is set for May 9th, 2024, again, in the morning. The exact time will be assigned closer to your hearing date. You're set for a jury trial on May 20th, 2024 to commence at 9:00 a.m. in the courtroom in Goshen. If you fail to appear for any reason, we'll have the trial without you. You don't have the opportunity to confront or cross-examine your accusers, as guaranteed to you not only by the U.S. Constitution, but also the Constitution of the state of Indiana. Not have the ability to aid your attorney with your defense, and not the ability to cross-examine any witnesses. And you'll be bound by the decision that is reached by the jury in your absence. Do you understand what will happen on May 20th, 2024 at 9:00 a.m. if you fail to appear for any reason?
Yes, ma'am.
All right, anything else?
Okay, now we got through all that boring stuff. Wake up, people, wake up, because now it gets good.
All right, have a good day.
So I can't be released.
Let me see if there was a bond set.
There was one set for 10,000 because I missed it. The reason I missed it is because.
Okay, so are you requesting a bond review hearing?
Please, because my cousin was 8 by the that day.
Well, ma'am, I'm not going to get into the particulars right now. I'm just going to set it for a bond hearing. I have to order a bond report from probation. We'll set it for a bond review hearing. Your attorney will be here to represent you on February 15th, 2024 in the morning. The exact time will be assigned closer to your hearing date. Thank you.
So it could be what?
No, I will not consider a bond until I have a bond report, and that'll be on February 15th.
Because, ma'am, I went to court. I bonded out on Christmas.
Ma'am, you either post the $10,000 bond or...
No, I bonded with that 10,000 thing. I did bond.
Oh, you're on a no bond hold because of a failure to appear?
No, I bonded out and they arrested me on nothing. I bonded out on Christmas on the 29th, I come into court. I was into court with the judge. He was supposed to pull back the bond and I guess he didn't. It didn't go through. They said the paperwork.
So you already had an initial hearing?
A what?
You already had an initial hearing. Everything that I went through today, you've already had?
Yes. I went to court on the 29th. I went through all of it and I don't understand why I was arrested.
Looks like there was a failure to appear warrant issued by Judge Kristen.
Right.
Judge Spataro.
And then I appeared on the 29th in front of him. Because on the 25th, I bonded out of jail. And on the 29th, I had court. I went into the court. I've seen him. We spoke. He went through everything. And I don't understand why I got arrested on the same bond. I did bond out. That's why I don't understand why I'm still here and why I'm still going through it. They said the weight of the paperwork would catch up to get another court date because they didn't have one right at the time. They told me call within 72 hours. I called, she says, we don't have all the paperwork on you yet. Give us a call back another 3 days. And I got arrested.
Looks like there was a court hearing on December 4th of 2023 in front of Judge Spataro.
I went December 29th to court.
I don't have anything about December 29th.
I was bonded out December 25th from the county jail. And on December 29th, I went in front of the judge.
And I don't see that, but I do see that the public defender was previously appointed back in October.
Yeah, I went into court, and that's why I didn't understand why this went through again.
I see a bench warrant that was issued on the February 4th that was placed, December 4th, 2023.
Right, and I went to court. I was in jail.
For $10,000.
Right, and I just bonded out.
I have.
December 25th, I bonded out, and December 29th, I went to court. That's what they said, that the paperwork wasn't catching up or something.
I don't see that there was a hearing held on December 29th.
It was right at the courthouse.
Ma'am, it wasn't me. I don't know.
It was I don't even know what judge. It was the littler judge. It was a little smaller.
In the jail?
No, I was at the courthouse. house.
So it was Judge
bonded out.
Pacharo?
Yeah, I bonded out on the 25th and I had court on the 29th. They said, make sure you make it. I made it up there to the 29th, into court. I went into court. I talked to him. He said.
Do you see anything about anything in December?
I don't, but I'm really concerned she has a public defender and she's not being represented right now. That's
Right. So why don't we reset this to next week? And I'm going to have my staff call the public defender's office and have them sort it out, because hopefully the public defender that represented you and was in court with you.
She wasn't there. She wasn't there.
Why was there no public defender in court with you and something was done?
I don't know. That's why the judge didn't understand why the paperwork wasn't catching up, and he didn't know where all the charges were, and he said.
I don't know either. So, I mean, the charges have been here since 2022.
I know, and that's that's why I was trying to get through the court hearings and I was showing up at court.
And I don't know. So, and I have what I have, and that's it.
That's why I was asking. No, why am I still?
So we'll reset it to next week.
If I bond, that's why I said if I bonded out, why am I still sitting here?
I have no clue. Again, I just got this case. I have no clue what happened before then, but I'll hopefully get it figured out before next week. Thank you.
Thank you.
I don't know. I don't know what to believe on this one. I'm going to tell you. There was a hot mic at the end that I didn't record because I don't want to get anybody in trouble. But the court staff, they believe that somebody messed up. However, some of the things that happened, like she had a hearing without a defender. What judge would allow that? None of them would. Like, they just wouldn't. You have to have your lawyer there if you have a lawyer. And she was given a lawyer in October. So it's not like the judge wouldn't have known she had a lawyer. And this was December. So I don't know who to believe. And I don't know what to believe. So, yeah, that one is interesting. She's going to put it off to next week. I can't promise I'm going to find out what happened because that's Indiana and I got to catch them live in action while they're happening. They don't record them or anything. So the last video I have, I put it at the end because it's possible that this was shown on some of the other channels. I don't know. I didn't have time to look to see. So if you already saw it, then there's nothing else after this. And have a great day. You can go. You're free to go. But if not, it's a whirlwind. It's just a whirlwind. Here we go.
Parties present on the McGregor versus Hope matter.
Yes, Your Honor. Kurt Holmes is here representing the plaintiff, Mr. McGregor, and Mr. McGregor is present.
All right. And Miss Hope, are you present, ma'am?
Yeah, yes, sir. Yes,
Okay.
sir. Can you hear me, Your Honor?
I can hear you. Can you hear me okay?
Yes, sir. Thank you so much.
Thank you. All right. We are on the record in Hector Van Lewis McGregor versus Julie Hope. The case number is Butler County 23 LM 1143. Mr. McGregor appears in person and by and through his counsel, Kurt Holmes. Ms. Hope appears in person and pro se. I am in receipt of several documents in the file, the original pleadings, of course, and also some additional documents, an answer, and then some supplementary information. Mr. Holmes, at this juncture, what is the particularized position and prayer of Mr. McGregor?
Your Honor, Mr. McGregor is the owner of the property in Andover. It is his home. During his pendency of living there in the home, Ms. Hope needed a place to stay. He allowed her to stay in his home for a period of time, a short period of time. However, Ms. Hope has continued to stay in his home and not vacate. And it has resulted in Mr. McGregor actually having to leave his home due to Ms. Hope's presence. And so we have filed an action under 61-3801 by delivering a 3-day notice to Ms. Hope. That was done on December 7th of 2023, asking that she vacate the home. And to date, she has refused to do so.
Okay. Ms. Hope, do you have any particular position or prayer on the case at this time?
We lost her, Judge. Give me just a second.
Okay, thank you.
Everybody's praying she doesn't come back, but she will.
Oh, can you hear me now, Ms. Hope?
I'm so sorry, Your Honor. I'm so sorry. I got disconnected.
That's okay. I'm glad you were able to come back in. Basically, in case you missed out on that part, Mr. Holmes had just summarized for his client the position they are taking, that Mr. McGregor had agreed to let you live in his home for a period of time, and that because of various issues, they're seeking your eviction from that home, and that's the request they're making of the court. Do you have any particular position or prayer today?
Yes, sir. Yes, Your Honor, I do. I've submitted some evidence via fax today, and in regards to the retaliatory treatment that Ms. Hope received. And pardon me as I speak in third person, it's a little bit easier, Your Honor. And Mr. McGregor and Ms. Hope had an agreement until the 16th, and then he submitted an eviction notice on the 7th, which was a breach of the contract that both parties had, number one. Number two, in regards to Ms. Hope trying to secure other residency and such and medical treatment, Ms. Hope received numerous threats, which can be provided via video, via recording. In regards to Ms. Hope's health, Mr. McGregor threatened Ms. Hope if she left the residence that she would be locked out. That also can be substantiated. Ms. Hope was just recently so sick that she finally was able to make it to urgent care. She does have a health condition of a tumor on her esophagus, and she was ordered a CAT scan in December. But because of her fear of any additional mistreatment or unlawful actions against her, as Mr. McGregor admits on video to using the police as a means to have Ms. Hope removed, and this goes along with her health, that Ms. Hope was so scared to leave the premises to get treatment for her health because of his threats to lock her out. And so she did finally, barely able to function, was able to make it to get the urgent care, and she was prescribed 6 medications. So Ms. Hope has a few motions to make. Number one, it would be to continue this case, and I'm sorry, I should have requested to start with the motion to dismiss it, Your Honor. And she does request a motion to continue it because she is just recently being prescribed for the proper medication and she is representing herself, and she is only asking for a week. And that would be a motion she'd like to have set this case for trial next week so she can subpoena the pharmacist she spoke with yesterday in regards to her concern because of the threats that Mr. McGregor has made regularly about Ms. Hope seeking medical treatment. And this is not the first instance that this has happened. And so Ms. Hope also submitted a notice to vacate on the 21st and will be gone in a week. So she does, and I apologize, Your Honor, I'm really not health-wise the best that I could be. And this is important to me, and I respect everybody's time. I respect
Or mentally.
this opportunity to speak, and I do like to follow through on my agreements. It just made it very difficult to leave on the assigned date when I received an eviction notice, and it had not even been, the time had not even expired, number one. Number two, Ms. Hope was scared for her health and safety. And number three, she wanted to speak and use her voice to advocate for her rights. Ms. Hope has provided a copy of an agreement where Mr. McGregor agrees to allow Ms. Hope to submit his car insurance dated back to October of 23, to submit to her insurance agency, as he signed a statement that Ms. Hope is legally residing in his property. Mr. McGregor claimed on his notice that Ms. Hope was at the residence illegally. And Ms. Hope would like to file a motion to dismiss the case because in that notice, Mr. McGregor stated that Ms. Hope was there illegally, but Ms. Hope had been there since September. So if from the understanding that Ms. Hope understands of the law, in her petition in response to the second petition and amended claim by attorney Kurt Holmes, she did address that pursuant to KSA 613803 and KSA 58256 or KSA 582570, Mr. McGregor didn't provide proper notice of termination of the tenancy. And he did not specify a cause for terminating the rental agreement early, as is required by law, either for not paying rent, for violating the lease, or a 30-day notice to terminate the lease. Ms. Hope believes that this eviction is a result of, it's a retaliatory action because Ms. Hope told the police on December 7th when they were here that Mr. McGregor had admitted to her on video and on voice recording prior on 2 occasions that he had just called the police to have her physically removed. And she told him that she was going to talk to the police and participate in that investigation. He's also, that's just one of the examples.
Okay, well, I think what I'm hearing you say is 2 or 3 different things. I want to make sure I'm understanding your requests. It sounds like you're wishing to file a motion to dismiss this action. You're also wanting to set this matter over 1 week for trial for purposes of getting any exhibits or potential witnesses in line and prepared and under subpoena. It's my further understanding that you're indicating that irrespective of all that, and correct me if I'm wrong, your intention is to be out of the home by, I think your letter said the 28th. Forgive me, I'm trying to find that here.
Thank you, Your Honor.
Okay, is that, have I summarized that correctly?
Yes, sir. I know I did present a few motions. Yes, sir. Yes, Your Honor. I did present a few motions, and yes, I have provided what I hope to be enough time for and a reasonable time, and in that letter stated specifically a 7-day notice to most definitely vacate these premises, absolutely, and never return to this property again, ever.
Mr. Holmes, we had received at the clerk's office here a letter today which communicates much of what Ms. Hope has explained verbally, including her intention to be out of the property on the 28th of January. With all of that background, what is your position with respect to setting a trial date a week from today, or any of the other motions or requests that Ms. Hope has indicated an intention to file?
Your Honor, we're present today. We'd like to move forward with getting possession. We're ready to move forward. So I would ask that her request to continue this be denied. As I've indicated, my client has had to vacate his own home, and she has completely taken over his home. She's had notice that she was to be vacated clear back on December 7th. So we think it's just further stall on her behalf, and really don't give much credence to the fact that she's going to vacate.
Okay. Well, I'm going to go off camera and off mic just for a moment. I just want to make sure I understand everything that's in the file here. I have reviewed it, but I want to make sure I haven't missed anything. And then I'll come back on and rule on her request, and we can go from there. Thank you.
Thank you.
Thank you, Your Honor.
See, a professional probably would have cut this out. I don't think he takes too long. But she's batshit crazy. Am I allowed to say that? Batshit crazy. And she's talking in court vibes thinks that she's batshit crazy. I felt bad for him because he was just being nice. Or it was his girlfriend. I don't know. Maybe let's just make the story up in our head. He was being nice. Let's stick with that story.
I do want to
Pressing play helps. Here we go.
All right, Ms. Hope, are you still able to hear me, ma'am?
Yes, Your Honor.
All right. I have had a chance just to refresh my recollection briefly. Ms. Hope, I do want to explain, you had mentioned a couple of times that there were exhibits in the file that the court may wish to consider. I'm not finding any exhibits as yet in the court file, so I just want to make you aware of that. I am going to grant the request for continuance for 1 week to January 29, 2024 at 2:30. Ms. Hope, I don't know what impact the exhibits that you're wanting to submit may have. I don't know what the evidence will be at trial. I certainly don't know what ruling I may make having heard that evidence or having seen those exhibits. But I do also want to explain that while I'm taking care to hear what you're saying, and I'm trying to be as best I can be even-handed in terms of hearing what you're saying as compared to the pleadings and statements from the plaintiff, I also feel it very important to understand that, from the plaintiff's perspective, Mr. McGregor is out of his own home. And so I would anticipate if at the trial next week, for whatever reason, you're not following up on what you had explained about vacating the premises on the 28th. And if at the conclusion of that hearing, I were to find that an eviction would indeed be appropriate, I suspect Mr. Holmes would have that paperwork ready and prepared to send to the court for immediate review and filing. And I just want to make sure, we're kind of all on the same page about the fact that there are no exhibits as yet in the file. And if you're wanting those to be heard, I'll need to have those available by next week. And also just to understand that there are very heartfelt interests on both sides of this case. I don't know where the evidence will lead, but if it were the case that the court were to make a finding in plaintiff's favor, I would anticipate that the intention would be on the plaintiff's part to try to, as quickly as possible, effectuate that eviction. So, that may be a non-issue in as much as you've expressed verbally and in writing your intention to be out of there by this coming Sunday. But I just want you to kind of understand the fact that the court file doesn't yet have the exhibits you mentioned.
Your Honor, may I speak, please?
Sure.
The police were knocking on my door. I did not answer them, though, but they were knocking on my door. So I hope that was...
I have no idea for what reason they would have been there, and I'm not going to weigh in on the appropriateness or inappropriateness of your actions in that context. But certainly, as far as this case is concerned, I am granting your request for continuance for 1 week. It will be my intention to go through to a conclusion when we reconvene next Monday at 2:30, and I'll look forward to seeing each and all here at that time.
Thank you so much, Your Honor. I appreciate you, sir.
Thank you, Mr. Holmes. Thank you, Mr. McGregor.
Thank you.
Thank you.
Thank you.
Poor guy. Poor guy. So in 2 days, they'll be back. I don't know if he's going to post the hearing or not. He doesn't always post his hearings, that judge. And I normally don't ever watch landlord-tenant cases because they're just all, I don't know, a different level of crazy. They're all crazy, but yes, Lightfoot, yes. The judge is using subtle language because he knows that she's gone. There's no evidence that she has. Or maybe there is. I mean, just because she's crazy doesn't mean that she's wrong. Maybe this guy really did give her paperwork that says that you have to be out at a later time. I don't know. I don't know what's going on in that situation. I just know some of the things that she said were crazy, so I'm calling her crazy. Oh, man. All right, well, I apologize about the Rolo update. There's nothing I could do about it. Next time I'll only have funny stuff. Oh, wait. No, that's not true. Okay, because I think I have a case. I have to look at it. It might be a little too long. It might be like 3 hours long. I don't know. But it's a corporation versus a corporation. So it's a lot of legal talk, but the lawyers are crazy. I'm going to try to see if I can put that together. Yeah, but that'll be funny. The next one will be funny. I promise. Nothing hard. Heavy like this one was. I hope you guys have a great day. Lightfoot, honey, go to bed. It's late. Bat shit crazy. Yeah, child, I don't know if I'm allowed to say that, but there's no other words. No other words. I'm glad you guys came out today. Glad you. Now, child, you can go back to that police where he sued the police department. Because why? Anyway, it's fine. You guys have a good day. It was good seeing you again.